In international law, we have no single legislative body which create internationally binding laws. We don't have also a system of courts with comprehensive and compulsory jurisdiction. Article 38 of the Statutes of the International Court of Justice is widely recognized as the most authoritative and complete list of sources of international law. Article 38, International Court of Justice status states that the court whose function is to decide in accordance with international law, such disputes as are submitted to it shall apply. A. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. B. International custom as evidence of general practice accepted as law. C. The general principles of law recognized by civilized nation. D. Subject to the provision of Article 59, judicial decision, and the teaching of the most highly qualified publicists of the various nations as subsidiary means of for the determination of rules of law. As we can see, the custom treaties and sometimes general principles of law recognized by civilized nations are considered as a primary sources of law, while judicial decision and teaching of the most highly qualified publicists of the various nations are considered as a secondary sources of law. Today we will discuss first primary sources of international law. After that, the secondary sources of international law. We will also quickly discuss the hierarchy of sources. It is important to mention that the catalog of sources mentioned in Article 38 is not a comprehensive catalog, and it's possible that the different act forms source of international law. Additional possible sources of international law can be found in UN Security Council resolution, which are binding upon the states, soft law, which is, for example, General Assembly resolution, which are not binding for the states, studies and reports of International Law Commission, unilateral acts of states like recognition, declaration, and protests. Starting from the international treaty or convention, which can be named differently: convention, international agreements, pacts, general acts, charters, statutes, declaration, and covenants. What is important to mention that we have binding unilateral declaration of the states and declaration which, according to general norms of international law, are created in situation when most states would agree to something, and this is often stated in declaration, proclamation, standard rules, guidelines, recommendation, and principles. While this type of declaration has no binding legal effects on state, but they represent a broad consensus of the part of the international community, and therefore have a strong moral force on the practice of state in their conduct of international relations. Example of this kind of no-binding documents is Universal Declaration of Human Rights. Coming back to treaties, convention, pacts, charters, etc. All terms refer to our written agreements in which participating states bind themselves legally to act in particular way or to set up particular relation between themselves. States that do not sign and ratify the particular convention are not bound by its terms. Treaties can be general, lawmaking, or treaty contracts, which apply only between two or small number of states. For many, treaties are the most important sources of international law, as they require the express consent of contracting parties, and therefore are being seen as a superior to the second source, which is custom. However, it is now established that even where a treaty covering the same matter as customary law, custom will not be simply absorbed within the former, but will remain its separate source of law. Custom. Rules and permissible behaviors develop in the society and are maintained by the members of the society. In early stages, in primitive society, they are not written down or codified, but when the society develops, the rules develop as well, and following that, courts and legislators' organs are established. And in the consequences, customs are being less important in the domestic system. In international law, custom is a dynamic source of law. Because of the lack of centralized governments, because of the lack of the legislative body, which creates the law. Custom contains of two necessary elements: usus, which is behavior of states, and opinio juris, sive necessatis, the psychological or subjective belief that such behavior is a law. Usus, which is the behavior of states. So as mentioned in the Article 38, it is this evidence of general practice. What would be then different between custom or, for example, courtesy in the international law? Now, to help distinguish between custom and, for example, courtesy, we have the second element, which is opinio juris, the psychological or subjective belief that such behavior is a law. The belief by a state that the certain behavior is a state legal obligation. In this way, we can distinguish opinion juris from, for example, goodwill. Part of the doctrine, however, is on the opinion that opinion juris is impossible to prove. According to Kelsen, for example, only courts have power to decide whether any behavior or state create custom, and opinion juris in this case is not a final verdict in creating the custom. International Court noted in the Libya and Malta case that the material of customary international law is to be looked for primarily in the actual practice and opinion juris of state, even though multilateral convention might have important role to play in recording and defining rules deriving from custom, or indeed in developing them. We can also look at the jurisdiction of the Permanent Court of International Justice in the famous Lotus case. There was a collision on the high sea where international law is applicable. Collision took place between French and Turkish ship. Many people died, and Turkey was on the opinion that the collision happened because of the negligence of the French officer. When French ship came to Turkey in Istanbul, when French ship came to Istanbul in Turkey, French officer was arrested. Turkey claimed that they have jurisdiction over the French officer. France was, however, on the opinion that according to customary rule, they have a jurisdiction over the French officer. To justify this, France referred to the absence of this kind of previous criminal prosecution. The court rejected France's point of view and decided that even if such practice of abstention from criminal proceeding could be proved in fact, it would not create a custom. It held that only if such abstention were based on the states being conscious of a duty to abstain, would it be possible to speak of an international custom. Thus, the essential ingredient of obligation was lacking, and the practice remained a practice, not a custom. Coming back to usus. As we say, it is behavior of state. For how long and how consistent state has to repeat some behavior to create custom? Again, in international law, there is no one rule, and everything depends on the circumstances. The court declared that the customary rule must be in accordance with a constant and uniform usage practiced by the states in question. The asylum case was about the Peruvian national who after revolt was granted asylum by Colombia in embassy in Lima. Peru, however, refused to issue safe conduct and refused to let the Peruvian national leave the country. In response, Colombia brought the matter before the International Court of Justice. Court decided that state practice in this case were uncertain and contradictory, and Colombia cannot claim it was a customary law. The court declared that the party which relies on a custom of this kind must prove that this custom is established in such a manner that it has become binding on the other party. When state acts contrary to an established customary rule and other states notify this, then that state is not to be treated as bound by the original rule. State which acts in this way in international law we call the persistent objector. Because law requires constant in develop, it has been accepted that whereas states make it clear that it does not agree with rules which appear to be crystallizing into law, that an objecting state will remain unbound. General principles of law. In municipal law, sometimes courts have to decide a case, but there is no law applicable. Sometimes courts have to use an analogy from existing rules or general principles. Court might decide on the principle of justice, equity, or consideration for public policy. Because the international law regime is not totally comprehensive, and we don't have already international law for every unique event, general principles are sometimes necessary. The phrase general principles of law refers to legal principle which exists in almost all domestic legal system. General principles of law are the core legal ideas which are common to all civilized systems. In the Chorzów factory case in 1928, which followed the seizure of factory in Upper Silesia by Poland, the Permanent Court of International Justice declared that it is a general conception of law that every violation of an engagement involves an obligation to make reparation. So as we see, the obligation to make reparation or recognition of the principle that violation of an obligation leading to injury or damage leads to reparation is considered as a general principle of law. Another crucial general principle of international law is pacta sunt servanda, or the idea that international agreements are binding. Another principle is the principle of good faith. As mentioned before, Article 38 include also the so-called subsidiary source of law, which we will discuss now. Once more, let me read the Article 38.d. Subject to the provision of Article 59, judicial decision and the teaching of the most highly qualified publicists of the various nations as a subsidiary means for determination of rules of law. Article 59 states that the decision of the court have no binding force except as between the parties and in respect to the case under consideration. So it is important to mention that in international law, there is no doctrine of precedent, which is known in common law system. Many international courts of justice decisions have been extremely significant in the development of international law. ICJ also alluded to its previous decision while deciding the case. The last point of today's lecture is the hierarchy of sources in international law. So as we know, Article 38 itself created a very general hierarchy of sources of law by distinguishing between primary sources and the secondary one. The question that what will be higher in hierarchy in the situation on conflict between the primary sources of international law is more complicated and will not be discussed today. Today, I just want to quickly discuss the Article 103 of UN Charter, which states that in the event of conflict between the obligation of the members of the United Nations under the present charter and their obligation under any other international agreement, their obligation under the present charter shall prevail. So as we see, Article 103 states that in case of conflict between obligation under any international agreement and the UN Charter should be higher in the hierarchy, and the obligation under the present charter shall prevail. At this moment, it is also important to mention that in international law, we have this kind of norms, which are called jus cogens norms or peremptory norms. They are fundamental principles of international law, which are accepted by the international community. The derogation from this norm is permitted. Examples of such obligation include the prohibition of genocide, protection from slavery, and racial discrimination, prohibition of piracy, or prohibition of torture.